Ladies and gentlemen, our next discussion brings us to the dynamic intersection of business strategy and growth, the world of joint ventures, mergers and acquisitions, private equity, and venture capital. In the ever-evolving landscape of India's corporate sphere, these avenues have emerged as critical drivers of expansion, innovation, and competitiveness. Today, our distinguished panelists will dive into these realms, exploring the trends, regulatory nuances, valuations, intricacies, due diligence imperatives, and the art of cultural integration. I now invite Siddharth Marwa, Principal Associate, Khaitan and Company, to moderate this session.
So the first question to Shwetambre, in your experience, what has been the most challenging regulatory hurdle in the PE and M&A transactions in India, and how do businesses effectively navigate those? And just in a continuation of that, how have the challenges in the regulatory framework in recent years impacted investor confidence and appetite for transactions in India?
Okay. When you say most challenging, we as lawyers look at it as interesting and exciting tasks that we need to navigate and structure, right? Whether it is us doing this along with valuers, authorized dealers, or tax advisors. So let me talk about these tasks or some of the concerns that we've faced as lawyers doing cross-border M&A deals. The first point is under FEMA, the pricing guidelines, right? We all understand how, whether it's a resident, non-resident buying shares from a resident, the pricing shouldn't be lower than the FMV. When the non-resident is selling shares to a resident, we have to ensure that the pricing is not higher than the FMV. Sounds reasonable, but while we are in the middle of a deal and we're talking about some of the challenges that we face is, one, when there are multiple prices for multiple sellers. And many deals we have multiple sellers where we have residents as well as non-residents. And third is when we're talking about a primary round as well as a secondary round. And the secondary round is at a discounted rate. So this pricing, ensuring that the pricing guideline is met is very critical. And we have to try to figure out how we navigate it or structure the deal, whether it is, first of all, making sure that we get the right FMV, right? So that no seller feels that they are not getting the right price. So, and if they feel jilted in any way, we have to figure out how do you structure it.
So, Pratibha, the question for you is that, how has the shifting global economic environment influenced the current trends in PE and M&A sectors in India, especially concerning key industries and deal sizes? Also, just an extension of that, given the recent activity in the PE and M&A landscape in India, which sectors do you believe will drive India's growth story going forward in the next 3 to 5 years, and why?
When you're sitting in India, you realize you're still an elephant. I think under Prime Minister Modi, we're trying to get our claws out, but I think we're in the right path. But for the last 3 years, we've still seen, consistently, it's been $60 billion plus investment coming into the country. This year started slow, so we were all wondering, with all the positive noise, where's the money? Ultimately, that's what matters. But August was good. August actually saw, I think, double the amount of investments than August last year. So, that's good news. And we are hoping that the rest of the year will help catch up to what, the first half of the year wasn't able to achieve. The China Plus One strategy is definitely playing in our favor. I think investors that had traditionally not looked at India, especially after the first round where, we had both the foreign exchange issues and the exit issues. After that round, they hadn't come back. They're coming back, which is good news. I was just in Seattle 2 weeks ago, and everybody you met from the Biden administration was talking about how both US government and US investors are talking about how important India is. So overall, everything looks rosy. I'm just waiting for it all to convert and us not messing up, whether from a regulatory perspective or the G2G, what's happening with Canada, that can't be good for economics. So, as long as all of that is stable and then elections are coming up and it shouldn't throw any surprise. So we always, with a good, robust democracy, you have to remember there are always, those ifs and buts that can always come up that worry you. But we've put in strategies to make sure that, that doesn't affect us. So for example, we do a lot of cross-border deals. We invest in the front offices in the US, which then have significant back office services in India, for example, IT, healthcare, both provide that opportunity. So you find strategies around it, which leads me to the second part of your question in terms of sectors. I think infrastructure still remains very, very hot, especially clean energy, climate impact, anything around that.
Coming to valuations, I think that's always a hot topic when it comes to startups. And, so when restructuring deals, how do you balance the various expectations of the investors with the realities and potentials of a target company? How do you do that? And in the context of the current business environment, what are some of the innovative strategies or tools being employed to mitigate risks and maximize values?
Thank you, Siddharth. I think, in today's business landscape, along with the, rapid technological advancements and the dynamic market shifts, the strategic choices that the businesses make is pivotal to their success. At the same time, the collaborations they do is also what determines the destiny of a company. And I think that's where the lawyers come in to, bring the best deal for the investors. And I think it's very important as lawyers for us to strike that right balance between not just, looking for the investor expectations, but also same time, what are the needs of the target company. And I feel that some of the key factors for this would be a thorough diligence. I think a diligence brings out the, the financial and the legal health of the company. It lets you know what are the compliances, regulatory frameworks in place, and also helps you understand the risks and the challenges that are, attached to the target company. I feel also that it's important to have an open and a clear communication channel with your, investors, informing them of these, the so-called red flags right in the beginning, because that's what is going to, help them also understand the direction the deal is going to take. Adding to that is the, determining the fair valuation of the target company. I feel that is one critical aspect which completely decides, how the deal proceeds and whether you really want to proceed with the deal also or not.
So, coming to due diligences and risk assessments, given the complex nature of PE and M&A transactions, how do you prioritize the various risk factors during a due diligence process, and what are the common pitfalls that businesses should be aware of?
Yeah, so especially with the increasing M&A activity, of course, due diligence takes a lot of priority, especially because of the fact, the general principle, buyers beware or caveat emptor. So you need to know what is it that you're getting into as an investor, as an acquirer. So what happens is assessing the financial as well as the legal health of a company, where, and as Suhani was mentioning, the scope of diligence also of late has expanded. It's no longer the traditional just legal financial. You have technical diligence, you have ESG compliance, ESG diligence, which is gaining a lot of foothold. Then, of course, with the Digital Data Protection Act also being enacted by our country as well, even data protection, cybersecurity, privacy issues also are gaining a lot of importance. In this scenario, what basically becomes very important for a lawyer, of course, is to ascertain the risks. A duty of a lawyer is not just to find the risks, but also to find solutions to the risk. And as commercial lawyers, our priority is to ensure that we kind of bucket the risks properly so that we are able to give so that the client is able to make informed decision and we are able to give them a sound legal advice.
So thank you so much, everyone. Thank you so
Thank
much
you,
for being
Siddharth.
part of the panel.
Thank you,
It's
Siddharth.
been great.
Well, moving on to our final discussion, rather conversation of the summit today, which is on navigating the digital landscape, exploring data privacy, protection, and cybersecurity under the Digital Personal Data Protection Act 2023, addressing challenges and safeguarding strategies. Through this discussion, we shift our focus to a topic of paramount importance: data privacy, protection, and cybersecurity. And to moderate this conversation, I'm calling on stage Dr. Manoj Kumar. Let's welcome them with a huge round of applause, please.
Introduce the topic of the discussion today. It's navigating the digital landscape, exploring data privacy protection, cybersecurity under the new Digital Personal Data Protection Act of 2023, which came about in August this year, and addressing challenges and safeguards and strategies that we need to keep in mind. I would request the panelists to share their perspectives. Can I start with you, Rajiv?
Sure. Thanks, Dr. Manoj. Everyone. When I think about this topic, what often tends to happen is I kind of unconsciously tend to switch to wearing the hat of a citizen as well, right? When you approach this one, this is something which affects you as a citizen, and then you kind of consciously make a switch back to wearing the hat of that in-house counsel and thinking that way. So I'll be speaking more from the perspective of an in-house counsel trying to implement the framework, in India, though those views are personal, as Mr. Vij said. A great piece of legislation to start with. We had to make the start somewhere. Though at an academic level, we can keep debating endlessly as to the way it has been done, the level of information available, the level of delegation, etc., etc. I think at a practical level, this is a great piece of legislation to start with, right? And now, more than what the legislation says, I think in this kind of a legislation in a country like India, what is relevant is the way it's going to be rolled out. And that's where I think the government has conveyed. In fact, 2 days back, we were attending this session, the digital dialogues with the Honorable Minister, Sri Rajiv Chandrasekhar, where I was very impressed with the way he rolled out. He said two things he said. One, the rollout is going to be with minimal or zero disruption to businesses. And that's something which we are committed to. And the second part which he mentioned also was that we're taking a phased approach. We want to really see who are the ones who are not well or high on the level of tech infrastructure and give them more time to comply versus companies who are strong at that front, who may have, say, implemented GDPR, who's going to get a shorter time to implement. Now, I thought that was good, and what he also asked us to do was to get back with specific concerns, if any, right? Specific concerns on specific provisions with timelines that we need to implement. So
it's very pleasing to see that we have a government which has the ears to the ground. So even the law has taken time, but we have somebody who is driving the law implementation, who understands the nuances, and therefore we expect this to have a much softer landing than what we have seen with respect to other laws which have come in. Vineet, some words from you?
Yeah. So I think I second what Rajiv just said. I think it's a great legislation. At least we now have a legislation. We've been debating for a couple of years now. As a Indian IT services company, we were often questioned as to what's your privacy laws, etc. So we were referring to anything and everything under the sky, satisfying the customer that, look, India is a great place to land your data, it's all safe, don't worry, and so on and so forth. But we had no legislation really so as to say, here is a piece of legislation that is there on record now. So I think from that perspective, it's a great start. it could not have been better for a fact that it's a very simply laid down law. Uh, Unlike those complex ones, so I think that's another great piece of work. And as you rightly said, I think, and without digressing from this topic, we've seen couple of, including the foreign law firms' entry into India. I know it has its own complexities, but there are a lot of things that we are doing good, to my mind. And this is one such thing in the same direction.
Talking about the next phase in a Bar Council event inaugurated by none other than the Prime Minister of India. So well timed, and it's definitely a great and a significant move. Manish, over to you.
Thanks a lot. First of all, I think this is the first act which is addressed as her. And that's a fantastic move by the government, because the Women Reservation Bill and seeing the women empowerment, that's the first point I noticed, and I really believe that we are progressing in the right direction. Of course, all of you must have read the act, but just to be more clear about it, this is digital personal data protection, and the word digital is very important. So anything which is not digitized is not under the domain of this act. The act has been, it's a dynamic act, and it's very different from the other act, of course, which is the Global EU Act, which is the Global Data Protection Regulations, or maybe the California legal rules which are there. So this is a dynamic act, means that as the technology evolves, you will not have to change the act again and again. So a very right step in terms of looking at data, recognizing who's the data principal, who's the data fiduciary, who's the significant data fiduciary, and also having right protections in the right place to begin with.
Anurag, your inputs, please.
Yeah, so, I would like to highlight one thing with regard to this act. This is one of the acts where I've seen it from the case laws to coming into a bill and then transforming into act. And one of the most important thing, if you see the bill and the act, it's completely some of the things which were so disturbing for the industry that has been moved out. So it seems like this act has actually taken the concern of the stakeholder first. If we are the companies or our clients are the companies who are going to implement it, this act and the bill, the transformation shows that there is some openness with regard to this act, where this act take care of data principle as well as the requirement of the data fiduciary. Now, the other things with regard to the act is that it's actually a very open-ended. It doesn't prescribe too detailed into like the things like sensitive, critical data and all those things. I think that has been left for the rules and the sectors to handle it, rather than bringing that into the act. The other important aspect with this act, which I just like about it, is that it also gives you a prescriptive manner, like with the examples and other things. If you see the comment given by the government that this particular act, we are bringing examples so that you can understand how this legislature wants to apply this act. Now that, if you see those examples, it's actually very important for a layman or for someone who is looking into this act and trying to understand it from the government perspective.
Anurag, I want to continue with you with the next question, to come to you on that, on the implications of the act on corporates, particularly with respect to data handling processes or management strategies or whatever else you think is relevant from the corporate's perspective.
Yeah, so this is coming for the first time. The implication is going to be there. There are so many things which is still to be understood from a industry perspective. Like, for example, one of the things which we were also discussing with regard to the purpose. When you say that one has to take a consent with regard to a purpose, then how specified that purpose can be. And given in today's world, when data is keep coming up and it has been used for so many purposes, which may be compatible, which may not be compatible. So the definition of the specified and then the application of that word is specified to the real-time issues which is coming up, or the real-time consent which is being taken up, is something which it will test the waters. Second important aspect is that, how specific you can be. You can take consent, but one need to understand that there is a concept of compatible consent. I have taken a consent, but I can using for the same purpose, but in a different manner. Will that be allowed, not allowed? Is there a concept of function creep going to come in at some point of time, where I'm overarching the consent? Once the consent is over and you start using the data, then the entire issue of this erasure of data, giving reports to the data principals, it will have its own technological issues, it will have its own implementation issues in an organization. I believe that the government as well as the board will be open to understand it's easier to write it in a law, but then it's very difficult from a technological perspective. That's what we understand from our clients, that nobody can ensure when it comes to in today's infrastructure. If someone has to certify that personal data of a data principal has been 100% erased from an organization, I don't know who is going to sign that letter, but best of luck to them. But yeah, those are the real-time challenges which will always be faced by the industry when it comes to implementation of this act.
We keep our side of the bargain by ensuring that we do actually what is practicable, then probably further interventions may not come. Perceivably, there are gaps which are open, and I'm sure there are courts and there are stakeholders who take the issue back to the government, industry body interactions with the government, and at some point we'll sort it out wherever there's a grievance with any rights of a data principal or lack of parity amongst the stakeholders. I'm sure courts are there to intervene and ensure that everybody gets an equal treatment. With this, thank you so much to my esteemed and distinguished panelists, Rajiv, Vineet, Manish, and Anurag. Thank you so much for sharing your views today. Thank you.